Thank you all for coming. I'm glad to see such a big crowd. My name is Jim Spangler, and I'm the president of the American Constitution Society, our student chapter here. Thank you for coming to this panel on marriage equality in the Supreme Court. I know it will be a really interesting one. I want to thank our co-sponsors briefly, Outlaw, Feminist Law Forum, and Law Students for Reproductive Justice. And I'd briefly like to mention just a couple of upcoming events. This Thursday at 4 p.m., David Cole from Georgetown Law, who's a professor there, pretty well known, he will be here to discuss the question, can the president order American citizens killed without trial? I know a lot of the faculty are already excited about this event, and it's open to students as well. So I hope to see you all there. Next Monday, April 8th at noon, we will have Indiana Supreme Court Justice Stephen David here. He will be talking about his life in the law, his work as Chief Defense Counsel for Guantanamo detainees, and life in the Supreme Court. Please RSVP for that event on simplicity so we know how much food. And finally, next Wednesday, April 10th, Louise Melling of the ACLU, she's the Director of Liberty there, will give a talk titled, The New Age of Abortion Restrictions. Listen up, it's about you. That's co-sponsored with Law Students for Reproductive Justice in this law forum. And she will talk about the state of legal abortion 40 years after Roe. So without further ado, I will forego introductions of our esteemed panelists who you know and turn the event over to our panel moderator, Professor.
Thank you for that very kind and elaborate introduction. We will proceed without further ado. Basically, we're going to talk sort of from that end to this end. Professor Scott will talk about issues of justiciability, and then Professor Sanders will talk about the Perry case. Professor Weiss will talk about the DOMA case, the Windsor case. Professor Johnson and I will add whatever we choose to say after that. So, Professor, and we'll have Jim keeping time. We're going to try to get through our initial comments as quickly as possible to allow as much time as possible for comments and questions from all of you. So, Professor Scott.
So these cases, Perry and Windsor, have been in the news a bunch. People waited in line for days to get into the oral arguments of the court. I can only imagine how disappointed they were when, at the start of both arguments, the parties talked about nothing but standing for the first half hour, a kind of boring procedural issue, but critical to understanding how these cases might come out. So my responsibility today is to talk about these threshold jurisdictional questions that might end up disposing of one or both of these cases without ruling at all on the merits or by limiting the kind of result on the merits that might result. So under Article 3 of the Constitution, the judicial power of the United States extends only to cases and controversies, and the Supreme Court requires, as part of that limitation on its power, that the parties to a case have standing, by which the court means a concrete and individualized personal injury that is actual or imminent. And the federal courts do not issue advisory opinions. They resolve only conflicts where the parties actually have a stake in the dispute. And this limitation applies not only at the district court level, but on appeal. So in 1986 in Diamond versus Charles, the court held that an appellant lacked standing. He was a doctor who was ethically opposed to abortion, and he tried to appeal from an adverse judgment in one of the lower courts, saying, I want to appeal, even though the state conceded that the law was unconstitutional and chose not to appeal himself. The U.S. Supreme Court says, you don't have standing to take this appeal. Sure, jurisdiction was proper in the lower courts, but concerned bystanders who seek merely to pursue their own value interests don't have standing. You don't have a stake as just someone who cares about abortion, is ethically opposed to abortion. That's not enough of a stake. So the parties who bring the case to the Supreme Court have to have a stake in the appeal. And in both Perry and Windsor, that's the Proposition 8 case and the DOMA case, there is reason to doubt that the parties have that kind of interest. So in Perry, the only people who have appealed the judgment are the intervener defendants, who were the official sponsors of Proposition 8. They were responsible under state law for submitting the signatures and drafting the language, that sort of thing. And The state has declined to appeal. The state officials who were sued have conceded that Proposition 8 is unconstitutional and have elected not to appeal. So the question is, when you've got agreement between the plaintiff and the defendant in the lower court, can an intervener, these initiative sponsors, bring the appeal? Very similar case to Diamond versus Charles. The big difference is that in this case, the California Supreme Court was asked by the Ninth Circuit what the rights of these interveners were as a matter of state law. And the California Supreme Court wrote a very strong opinion that granted, holding that the official sponsors of a ballot initiative have authority under state law to assert the state's interest in litigation to defend a ballot initiative when the Attorney General and the other state executive officials who ordinarily have that responsibility decline to defend the constitutionality of the ballot measure. And so the panel of the Ninth Circuit unanimously held that these individuals do have standing, that these official sponsors are appointed by the state to represent the state's interest. Critically, nobody at this stage thinks that they have standing in their own right, just objecting to gay marriage, thinking that the law is constitutional. That's not enough. Instead, under state law, the theory goes the state has been injured, and that's no question it has. There's been a permanent injunction against the state entered in the lower courts. And so these people, as representatives of the state, can assert that interest because the state officials have declined to do so. And there's some reason to think that this state law question matters to the disposition of the dispute. So in Karcher versus May, this is another mid-'80s case, the state law had granted the legislature, rather than the executive branch of the state, authority to defend state law when the executive branch declined to do so. And the U.S. Supreme Court held that the legislature, therefore, the state legislature did have standing as a representative of the state in light of that state law. Likewise, in Arizonans for Official English, you had exactly this situation. A ballot measure passed, and the official sponsors wanted to appeal after the state executive branch officials declined to do so. And the Supreme Court, this is dictum, but the Supreme Court said, we have grave doubts about whether they have standing to do so. After all, we are aware of no Arizona law appointing initiative sponsors as agents of the people to defend, in lieu of public officials, the constitutionality of initiatives made law of the state. We do have that express authorization here because the California Supreme Court went to great lengths to make sure that the initiative sponsors possess that power. So the Ninth Circuit held that there was standing. The strongest arguments, a number of arguments against standing at this stage in the U.S. Supreme Court. Essentially, the attack is on one characterization of the Ninth Circuit's opinion, which is, did the Ninth Circuit say that the state can assign anybody, without any limit, the power to represent the state's interest? If that's true, that seems like an awfully broad grant of authority. Doesn't that contravene this principle that generalized grievances, just objecting to a decision, ought to give standing to anyone? And so it's a kind of parade of horribles. Here are some of the suggestions from the briefing. What if state law assigned everybody in the state, or every taxpayer, the right to represent the state? Doesn't that do an end run around long-standing rules against citizen standing or taxpayer standing? What if the initiative sponsors disagree with one another? There are 5 official sponsors. What if they disagree about strategy, about something like that? Who then represents the state's interest? What if the initiative sponsors mismanage state funds? If they spend too much money defending the state, or they get a huge judgment against the state, and under Section 1983 they're required to pay attorney's fees? What if the challenge doesn't come until 20 years later? Do they really have a permanent forever? They're going to represent the state's interests on this issue, even after the organizations or the individuals are dead or they've changed their minds? This seems like, in theory, it could be a very broad grant of power. And after all, state law can't grant Article 3 standing. This is always a question of federal law. Some of these, it seems to me, are practical problems for California to think about when it authorizes somebody to represent the state. Not Article 3 problems, but practical problems. And in fact, the California Supreme Court, in its opinion, addressed a number of them and said, we don't need to decide these outer boundary questions. But the real problem is that they all seem to be objections to somebody else's standing. In this case, you've got exactly 5 people who have standing. There's not a floodgates problem. You're not giving citizen standing or taxpayer standing. It's a limited class of people. It's an immediate appeal, an immediate challenge, so there's not a real timing problem. They're spending their own money, so there's not a mismanagement of the state's fisc issue. In short, these seem like problems with somebody else's standing in a future case, and the court could easily hold in this case that these people have standing, even if there's some outer limit to assigning standing to other kinds of representatives in future cases. And Justice Kennedy, by the way, said exactly this at oral argument in the case. It seems like these kinds of issues are better reserved for a future case where we actually get a more aggressive grant of authority by a state. If the state court decides there is no standing, I predict it will be because they invent a new requirement, which was suggested by my old boss, Walter Dellinger, in a very good brief, arguing that there was no standing. And his argument is that a person who represents the state's interest must be an agent of the state who owes a fiduciary duty to the state. And that requirement appears nowhere in the court's previous requirements, but it would be a way of saying these folks don't have standing and leaving open the possibility that there's some future class, some better assignment of authority to representatives in a future case. Let me also address the standing issue in Windsor. So that's Perry. That's the initiative sponsor. Do they have authority to appeal? In Windsor, there's a slightly different problem, which is that the people who are appealing, the United States of America, the defendant in the DOMA case, the victims of the permanent injunction, agree that the law is unconstitutional, and they won in the lower court. And nonetheless, they've appealed. They say, thank you for ruling exactly as we thought you should rule. Now I would like an appeal to the U.S. Supreme Court because we want them to agree with you and say that this was unconstitutional. And this seems, so the plaintiff and the defendant are in agreement, but they want to appeal to get an opinion from a higher court agreeing with that judgment. This sounds like a real advisory opinion problem. And as everyone conceded at oral argument, this is unprecedented. No, we've never had a case in the U.S. Supreme Court where all the parties below agree, and yet they're seeking review by the higher court. So one theory here is that the United States is an aggrieved party, has standing to appeal because this is, after all, a judgment invalidating a federal law, and even if the federal government says that it agrees that the law is unconstitutional, it is continuing to enforce the Defense of Marriage Act for now. This is the controversial enforce but do not defend problem, and that decision of its own force gives the government standing to continue to seek appellate review to get an official proclamation from the court, the highest court in the land, that it's unconstitutional. There's another standing theory in that case, though, which is that the BLAG has standing. BLAG is the unfortunately named bipartisan, it's the bipartisan legal advisory group of the House of Representatives. This is a 5-member group that has voted on behalf of the House of Representatives to intervene in the case and to defend the constitutionality of the Defense of Marriage Act. It is not the whole House of Representatives, it's not the entire Congress, and that poses some problems. So the Supreme Court has held that individual members of Congress do not have standing to defend the constitutionality of laws. But in Chadha, you have probably read this case in your first-year constitutional law class. In Chadha, the court held, at least suggested, that Article III standing was available for an entire body of Congress, an entire House of Congress. In that case, both the House and Senate intervened and were deemed to have statutory standing under a review statute to review the case. And this is somewhere in between. You've got a House's advisory group that has rendered this judgment. Both of these cases raise a very similar problem, which is who has standing to pursue an appeal when the executive officials who ordinarily defend the constitutionality of law abandon the field and say, we concede this is unconstitutional. Do the Article III courts have jurisdiction to continue resolving the case when everybody seems to agree? And as a practical matter, there are concerns, and this is most acute in the Perry case, about the integrity of the initiative process. For example, if the state officials, the initiative process, whatever else you think about it, was designed to solve an agency problem. Because of interest group capture and corruption, we think we can't trust the elected officials of the state to do what we, the people of California, want to do. And so we have a ballot initiative process to ensure that laws pass that have majority support, despite the fact that those untrustworthy legislators and executive officials aren't vindicating our interests. Well, if, as a matter of Article III, the state can't assign the people who sponsor those initiatives standing to get into court and defend them, that means that exactly those people who the state doesn't trust are in charge of rolling over and playing dead when a challenge comes along to a state law. And this would be true not just in marriage cases, but pick your favorite ballot initiative, legalization of marijuana, whatever it is. If the state officials who usually are responsible for defending state law belong to the opposite political party and can roll over and allow the state law to be unconstitutional, that's a real agency problem for the state when you've got an initiative system in place. And so briefly, those are the standing issues. Sorry for taking that long, but they're complicated and end up taking a lot more of the oral argument than a lot of folks expected.
Great. Perry, the California case, was famously brought by what's often been called the odd couple of Ted Olson, a very distinguished Supreme Court advocate, typically allied, associated with the Federalist Society and the conservative end of the spectrum, and David Boies, a liberal trial lawyer. Nan Hunter, who is an academic at Georgetown, spoke for many, I think, gay rights advocates when they thought Olson and Boies were bringing this case too soon. Nan Hunter said in an article in the New Yorker a couple of years ago, she feared that the strategy basically boiled down to Ted Olson will speak, Anthony Kennedy will listen, and the earth will move. And that was always an oversimplified way of thinking about how the Supreme Court was going to address this issue. Well, it sort of didn't turn out that the way Olson and Boies thought it would when they got into this back in 2009. Or 2010, and so Professor Hunter may well have been proven correct. If you were expecting a clash of titans over the central civil rights issue of our time in this case, in looking at the transcript or listening to the arguments, it didn't seem that way. My overwhelming impression from reading the transcript was sort of how dreary the whole thing was. Not just because of so much of the focus on standing, which is intellectually interesting and important, but just the sort of lack of clear issues, of great inspiring rhetoric. I didn't think Ted Olson was particularly inspiring or on his best game. Justice Kennedy, who is seen as the swing vote in this, as in so many cases, seemed querulous, sort of, unsure why they were all there talking about this particular case at this time. Justice Scalia, as usual, seemed mostly there to sort of make trouble. If you wanted to learn something about equal protection or due process clause doctrine, you would not have learned much, if anything, by listening to the arguments in this case. Romer and Lawrence, the court's most significant gay and lesbian rights decisions, mentioned only in passing. Zablocki, the court's most extended treatment of the right to marry generally, mentioned only in passing. The court's liberals, or the moderate liberals, there are no true liberals on the court these days, the moderate liberals generally ask the right questions of both sides, I think, but they seemed frustrated by the fact that this particular case was an odd vehicle for the issue of marriage equality, since the Ninth Circuit, thinking it was doing everyone a favor by narrowing the case just so the court could strike down California's laws and not affect the rest of the country, the legal issues had been narrowed in a way that really only made it applicable to California. No one seemed happy with that potential outcome, with essentially punishing California for giving all the rights, benefits, duties, responsibilities of marriage to gay couples, just refusing to call it marriage. One way of looking at that is that's kind of a per se violation of equal protection. There's no rational basis there other than to sort of inflict an indignity on same-sex couples, giving them all the state benefits and responsibilities of marriage, just refusing to call it marriage. Most of the justices seem to think that it would be absurd to punish a state that wants to do the right thing for same-sex couples and say it's unconstitutional if it goes 90% of the way, but not all the way. Meanwhile, states like Indiana and Alabama and Michigan, which do nothing for the equality of same-sex couples, get to keep their laws the way they are. I was struck by the posture that the... I'm going to start talking.
Warning.
Okay. I thought it was because I was going to bring up Justice Scalia again. The posture that the court's conservatives consistently asserted, this posture of sort of willful obtuseness, I thought, about the whole phenomenon of same-sex marriage. They insisted on that marriage equality is some sort of potentially dangerous experiment, like legalizing marijuana or assisted suicide, something we'd better make very sure of before we unleash the consequences of this experiment on the whole country. There's a tendency to talk about same-sex marriage as if it doesn't yet exist, as if this is about the court bringing it into being. In fact, it's existed in this country for 9 years, currently in 9 states. We're closing in, I think, on 100,000 same-sex couples who have been legally married. Moreover, committed same-sex couples have been building lives together without benefit of legal marriage and often raising children together for many decades. The trial court in Perry, Judge Walker, who spoke from this very lectern less than 2 years ago, made detailed factual findings about the nature of marriage, the role of gender in marriage, the impact that defensive marriage acts like California's have on same-sex couples. It's as if none of that ever happened. There was a 12-day trial in this case in the district court, which people thought really would set it up as being very different from just a bunch of legal arguments about abstract equal protection and due process doctrine. Those factual findings about marriage and about the impact on the plaintiffs never seemed to come into notice by the justices, seemed to play no role in the arguments. I think I have to agree with the sort of mainstream consensus that the most likely outcome here is that the court will punt. There will not, as Jeff Stone, who teaches at the University of Chicago, has argued, there will not be 5 votes to uphold California's DOMA. 5 justices will not sign on to a modern-day Plessy versus Ferguson. Yet it's also sort of hard to see 9 votes coming about to overturn California's law. So I guess I agree with the conventional wisdom that they'll either rule that the defendants did not have standing, or that they will dismiss it for having been improvidently granted. That's another procedural way they could get rid of the case. Let me just say for the future, my last minute or two here, describe the next case I think should be brought if this wasn't the right case to present the issue of marriage equality to the Supreme Court. One, as I said, there are tens of thousands of couples that have already gotten married, but face having their marriage basically evaporate if they cross a state line. If you live in New York, get married, and then move to Indiana, pull up stakes and move here, Indiana says your marriage is void. That seems to me to be an incredible affront, a serious due process problem that's taking away something someone has already had seems conceptually and legally distinguishable from not giving it to you, not giving you a marriage license in the first instance. I think that's marriage recognition interstate's a well-established policy. I think that would be a much more sympathetic set of plaintiffs. The other kind of case I would like to see brought is a case that zeroes in on the differences between laws in states that prevent you from getting married that are just statutes where you just have to convince a legislature to change the law, and laws that are actually embedded in state constitutions. We now have in a number of states that prohibit by their state constitutions marriage equality, meaning you have to get a supermajority and then some sort of ballot initiative in most cases to get the law changed. That seems to stack the deck. That forces proponents of marriage equality to go through higher hurdles and extra burdens. So I think you could make an argument that if a mini DOMA is just statutory, let people work through the normal democratic process, convince your legislatures and change the law, as we're starting to see in some states. It's much more problematic, and I think much more warrants judicial intervention and judicial review when the mini DOMA is embedded in a state constitution. It means you have to go through a much more difficult process. The democratic process has been stacked against you. I think that's a potential argument that says we've seen a stoppage in the democratic process. It's not working the way it should, and therefore judicial intervention is justified.
All right. So I've been asked to talk about, excuse me, the Windsor case, which is the case that Nan Hunter and other gay and lesbian advocates thought should be the first case, or a case like it, that the Supreme Court would decide, and does deal with the reality that there are same-sex married couples now in 9 states plus the District of Columbia. So this is a challenge to Section 3 of the Federal Defense of Marriage Act, which states that for purposes of federal law, marriage is between a man and a woman. And it doesn't matter if you have a lawful state marriage. The federal government will not recognize that as a marriage. This is extremely important in sort of practical terms for married same-sex couples. Because federal law, there are more than 1,000 different legal provisions that use marriage as a marker for providing benefits or imposing obligations. And traditionally, the federal government has simply accepted whatever states put in place in terms of their own marriage rules. And if you were lawfully married under state law, for almost all purposes, you were considered married under federal law as well. So DOMA was a significant change in that. Now, at the time that DOMA was enacted in 1996, it actually wasn't, because at that point in time, there were no states that had same-sex marriage. There was just the hint that Hawaii might. So when it put it in place, it didn't actually change the status quo, but now that we have 9 states, it is a dramatic departure. And I think I also agree with the conventional, what's sort of out there at this point is the conventional wisdom in terms of reading the tea leaves of the argument that if they get to the merits on DOMA, there are not 5 votes for upholding this provision of DOMA. It does seem like there probably are 5 votes for holding that it is unconstitutional, but not quite clear what the rationale for that would be. So I think the 4 sort of liberal or moderate liberal justices would probably hold that it was unconstitutional because it violates the Equal Protection Clause. That is, that there's not a good enough reason for treating same-sex married couples differently from different-sex married couples. To some extent, this turns on whether sexual orientation receives heightened scrutiny. Under the Equal Protection Clause, that's what the Second Circuit held below. That's what the U.S. is arguing is appropriate. And I think certainly if heightened scrutiny is applied, the justifications that Blagg is arguing in terms of uniformity in the enforcement of federal law, or sort of sort of tying marriage to procreation, or matching what Congress thought when it was putting marriage in place in these statutes, are probably not enough to overcome the sort of closer look that we give, and are maybe not enough to even overcome so-called rational basis review, given that it is such a departure from the way the federal government has historically practiced, and is clearly causing a whole new set of administrative headaches. So those sort of uniformity arguments don't seem all that convincing. That said, at the argument at least, it did not seem like Justice Kennedy, who is expected to be the swing vote on this, was particularly taken by this line of argument. Instead, his questions really focused on federalism and whether it was an intrusion into the state's role of regulating marriage for the federal government to be coming up with a definition of marriage. I'd be interested to hear from my colleagues on this. This was a relatively unusual federalism argument. It was not argued by any of the parties in the case, so there are amicus briefs making this point. And it does seem that in general, the federal government has pretty wide latitude to define how it wants to give out benefits when administering federal programs. And I think that the sort of best way to see the federalism question is to turn it around. And this is what Justice Scalia and Justice Roberts and Justice Kennedy, to some extent, in the argument did, which is to ask whether the federal government could adopt a more generous definition of marriage than the states, whether the federal government could decree for federal purposes that that they would recognize committed same-sex relationships even if those couples could not be married under the state law. And when pressed on that, the Counsel for the United States and the Counsel for Edith Windsor both said they didn't think that that would pose any kind of federalism problem, which I think is probably correct. Blagg, in its brief, also made a point of saying that this would be fine. So none of the parties are contending that that actually poses a federalism problem. And I think that that's probably right from a federalism perspective. But what I think that question also highlights is a different way of thinking about the equal protection questions that are implicit in this case and in what might happen in the future. So right now, what's at stake in the Equal Protection Clause analysis with DOMA in place is obviously that same-sex married couples are being treated differently from different sex married couples. That is, if you're married in Massachusetts and your partner is the same sex as you, you're not married for purposes of federal law. If your partner is a different sex, you are married for purposes of federal law. And this is Justice Ginsburg's line about how we now have full marriage and skim milk marriage. Which, when I was looking at this, I did find blog posts saying, what's she implying that skim milk is less good than full milk? But if this provision of DOMA is held to be unconstitutional, then a new differential treatment question is going to arise. Because then you're going to have the federal government treating some same-sex committed couples differently from other same-sex committed couples, with that distinction changing simply on whether that couple lives in a state in which they may marry. And then you'll have this reality that as couples move, not only does their marriage come and go, but their federal benefits come and go, which is a little odd and is a little bit of a different question from states setting their own rules, where the federal government is giving out benefits on the basis of these sort of varying state standards. And it's also unusual in the sense that traditionally states have recognized their own marriages. So even when there are differences in whether states will say, let first cousins marry, if you got married in a state that did let you marry and then you moved to a different state, you stayed married. So you didn't lose that marriage and you didn't lose the federal benefits associated with that marriage. Now, of course, it's possible that the Perry case could end this if it were to hold that there is, in fact, a constitutional right to marriage that applies in all 50 states, but that is not going to happen. So I think that what is far more likely is that if they reach the merits of DOMA, DOMA will be struck down, this provision of DOMA, that the federal government will start recognizing marriages from states that permit marriages, and that we'll get to a sort of more and deeper pronounced division in terms of what that means, where now you will both have state benefits of marriage and federal benefits of marriage, and a kind of deep division as more states, the blue states, I think, are going to move towards permitting same-sex marriage. Now, the response could be that the federal government could level up. That is, they could, I think, say we're going to treat all committed same-sex couples and come up with some kind of standard of what that means and say that they could receive federal benefits, but they're unlikely to do so because they actually like the administrative convenience of piggybacking on the state system. And so I think that the sort of next equal protection analysis is going to be, does that administrative convenience of being able to piggyback on the state system justify the federal government treating committed same-sex couples differently simply because of the basis of the state they live in? And I don't know that we have a great analog out there that answers that precisely. So I'll stop there.
Great. So I will say just a few things. My colleagues have, I think, covered all the major issues, and I agree with just about everything they said. I just want to make basically one point, which is obvious, I think, to all of us, and that is how much our understanding of what constitutes unconstitutional inequality has changed over the last 30 years. You know, and I just have these snapshots in my mind that reinforce that for me, that I'll just say a couple words about. The end, though, I think, listening to all the arguments, is the court's not there yet, not ready yet, even though there have been these dramatic changes in the cultural understanding of what is a denial of equal protection. One thing I worry about is that the justices will take incorrect legal positions in this case in order to avoid reaching the merits, because I think what Ryan described about standing, I think clearly the parties have standing in these cases, but it gives the Walter Dellinger brief, you know, is designed to give Anthony Kennedy a way to not reach the merits if he's not going to decide it the way that Walter thinks is the right way, you know, and they talked a lot about the Dellinger argument against standing. And then the federalism argument that Kennedy put out there, Justice Kennedy put clearly wrong. None of the parties think it's correct, but it could be a 4-1-4 kind of split where he votes that DOMA is unconstitutional based on federalism grounds that are just, I think, clearly wrong. But so just very quickly, I think about how 10 years ago we had an ACS event in this room. It was a debate between the Federalist Society and ACS. Even then, though, the Federalist Society president of our law school chapter said, came up and he said, I just want to be clear, I'm with ACS on this one. And 90% of the students at that time were with Ken Falk from the ACLU, who was arguing in favor of marriage equality. And by the end, I don't know if anyone remembers that debate or was there, but the person arguing for the Federalist Society pretty much said, I'm right. I think I'm right, and I'm arguing what I believe is right, but I think you all just have to outlive me, and you will, and this will change. But we have to fight the good fight along the way. It was kind of his position in the end. But I was actually working for Walter Dellinger back in 1996 when President Clinton was confronted with whether to sign this bill, and we had to advise on whether it was the Defense of Marriage Act was constitutional or not. And so I have a very clear memory of long conversations about the different parts of it and where the state of precedent was at that time. President Clinton, on policy grounds, wanted to sign the Defense of Marriage Act, and I was working with Walter at the Office of Legal Counsel, and we all thought on policy grounds this was awful, but you could not say it was unconstitutional. I have a very clear memory of that. I also have a clear memory, Steve Sanders mentioned Nan Hunter, and back in 1988, I was working at the ACLU Reproductive Freedom Project, and Nan was starting up the LGBT project of the ACLU, and I was thinking about going to work for her, and we were talking about it, and I remember talking to some of my mentors and law professors. At that point, going from working on abortion rights to LGBT rights was viewed as becoming far more radical. That was the far more radical issue back in the 80s to be working on. Instead, I went on to work at National Abortion Rights Action League as legal director rather than LGBT issues, but I remember so clearly where those two issues were in the minds of the American people and politics and the status of precedent at the time. So, I just want to emphasize that I think even though the Supreme Court is not at this point, it seems from the oral argument, and that means Justice Kennedy, ready to take that step and say heightened scrutiny, or at least rational basis with fight, in these two cases means this discriminatory treatment of marriage is unconstitutional, and instead, I think, likely to go off on jurisdiction and federalism. I do think that the overarching lesson is the meaning of, when the framers used broad, undefined terms like equal protection in the Constitution to protect notions and principles of equality, that meaning changes as our understandings change as a culture and as social movements. I think enhance our appreciation of what is impermissible and equal treatment under the Constitution.
I will make three very quick points, sort of drawing some things out of the argument and also to some extent reflecting on things that may have broader implications beyond the cases in terms of issues of constitutional theory and reasoning, first of which picks up directly on Professor Johnson's comment about sort of changing meaning of the Constitution, and just highlight one part of the argument. You may have read about it in the media or heard it, as Professor Sanders might say, it's Justice Scalia making trouble. But precisely relevant here, Scalia asked Olson, I'm curious, when did it become unconstitutional to exclude homosexual couples from marriage? 1791, 1868, when the 14th Amendment was adopted, sometime after Baker v. Nelson, 1972, when the Supreme Court said it did not even raise a substantial federal question. When did the law become this? Olson sort of couldn't quite figure out how to respond to it. Ultimately, he says, consistent, I think, with what Professor Johnson just said, it was when we as a culture determined that sexual orientation is a characteristic of individuals that they cannot control. This is Olson, there is no specific date, it is an evolutionary cycle. Okay, so you've got the debate between originalism on the one hand, sort of living constitutionalism on the other, I think nicely reflected in that passage. Notice also Olson's reference to the idea of immutability. And in the Second Circuit case concerning DOMA, the circuit evaded the issue of immutability by sort of transforming that trait or that aspect of the Supreme Court's analysis with respect to whether a particular classification should be deemed suspect or quasi-suspect. Olson wants to say here it is immutable, and the court should indeed so conclude. Second point, also relating to when a classification should be treated as suspect or as quasi-suspect, the court often talks about political powerlessness. And I won't read it, but there were some nice exchanges between Chief Justice Roberts and counsel concerning whether political powerlessness is a condition that should be described historically or in terms of contemporary reality, and Roberts obviously wanting to make the point that homosexual people today, in his view, have lots of political power, and in fact there are strong political movements to in fact embrace same-sex marriage as a matter of political choice, therefore suggesting that the courts need not intervene in that fashion. Third point, and the one that actually intrigues me the most, is the issue of what the court will sometimes describe as unconstitutional animus, and whether or not DOMA, for that matter, Proposition 8, should be deemed unconstitutional because they are tainted by what the court has referred to as unconstitutional animus. And in the Windsor argument, you have, on the one hand, Borelli suggesting that DOMA was, as he puts it, driven by moral disapproval. Chief Justice Roberts. So that was the view of the 84 senators who voted in favor of it and the President Clinton, who signed it. They were motivated by animus. Borelli sort of backtracks a little bit. He says it was simple want of careful reflection or an instinctive response. Later on, Kaplan, who was actually the lawyer for Windsor, who got a little bit of time in the argument, interestingly, she didn't get a whole lot, she says, well, it wasn't really animus or bigotry, but it was misunderstanding. So you get kind of a suggestion that maybe this idea of animus, at least some of the justices are regarding this as a problematic basis for decision-making, one that in fact casts perhaps unnecessary aspersions on people who, at the time the Clinton administration signed this law, or Congress adopted it, or the law Prop 8 was passed by voters in the state of California, may not have been driven by animus or ill will at all. So query whether it would be better for the court to in fact embrace something like intermediate scrutiny explicitly than to in fact have to attribute some kind of evil motive to those who are in fact supporting a traditional understanding of marriage that has existed for thousands of years. At the end of the argument, this is who is speaking at this point? I guess this is Clement. At the end of the argument in the Domas case, he says, the last point I would simply make is in thinking about animus, think about the fact that, as Professor Johnson just said, Congress asked the Justice Department 3 times about the constitutionality of the statute. That's not what you do when you're motivated by animus. He goes on, the Solicitor General wants to say, well, it was one of careful reflection. He says, Clement says, where do we get careful reflection? We get careful reflection in the democratic process. We have a sea change going on politically throughout the country. It's not about animus, it's about whether an argument is persuasive. You don't label people as bigots to advance the political debate. Ask the federal, and he says, the federal Congress is not immune. They repeal, don't ask, don't tell. Allow the democratic process to continue. So I just want to highlight this issue of animus. Should we in fact be relying upon animus? Should we try to figure out what animus is? Or is that perhaps an unhelpful way to resolve issues that are sort of at the heart of the cultural debate that we've been having over the last however many decades? Let's open it up for questions and comments. Yes?
I was wondering if you guys could talk about why the court is so reluctant to see this as an issue about gender roles. Same-sex couples not being allowed to marry seems to me to be about the idea that the father and mother are both necessary, and the idea of what a father is versus what a mother is seems like a very gender role based idea.
Well, I think that's right. I wrote an article making that point. It's actually an argument that was tried repeatedly in the state marriage cases and really didn't seem to get traction. Even when you had things like the state, New York's highest court saying, well, it's just common sense that kids do best with a mother and a father because they provide different roles or something like that. And I think it's just this, it seems so natural that the court's not willing to see that as stereotyping and fitting into the line of sex stereotyping and holding that sex stereotyping does raise these issues. Now that said, in the Perry case, the district court actually did make findings on this point and held that it did constitute sex discrimination. But other courts have really sort of gone on, well, it's treating gay men and lesbian women equally, in that they're both being denied the opportunity to marry the person of their choice, and therefore there's no differential treatment on the basis of sex. I agree with you. I think that's hard to square with other aspects of sex discrimination doctrine that recognize sex stereotyping as itself a harm, even if you have, sort of equal treatment, but the court just, the Supreme Court wasn't really raised prominently in the parties' briefs, at least. I think there were some amicus briefs that did a little bit of it. But at least in the state court, it just never seemed to get traction. They all sort of said it's equal treatment, and that's the end of the story.
I'm trying to remember, it did come up in the oral argument.
It did a little bit in the oral
Justice
argument.
Kennedy,
and Justice
I think.
Kennedy,
Justice
asked
Kennedy
the
said this
question.
is a tough question, I think,
Yeah.
didn't he? And
Yeah.
who was he talking to? Was it Cooper or
I
Clement? I forget.
It
One
was,
of them.
it was either Cooper or Olson, yeah. But he said, I'm interested in this.
And they struggled.
Yeah.
They just didn't really know what to do with it.
Yeah.
Yeah.
Yes.
When you say too soon, is that too soon in terms of the progression of equal protection, or too soon in terms of vetting this in a case like Perry, or is that the wrong thing? Is that
Oh, go ahead.
Well, probably. Well, it could mean a number of things. Too soon in terms of public opinion, although national public opinion now is consistently in favor, by a slim majority, in favor of same-sex marriage. I think when people think the court is trying to determine whether it's too soon for this or not, the thing that the court is thought to most frequently look to is what's called a pattern of enacted laws. Where are the states on this? So when Roe was decided, the vast majority of states still criminalized adoption. There was a huge backlash against Roe, and now even Justice Ginsburg has gone on record as saying she thinks Roe may have been decided too soon. By contrast, by the time the court decided Loving, striking down laws against interracial marriages, only 16 states still did that. At the time of Lawrence versus Texas, only 4 states still singled out same-sex sexual relations for criminal prohibition. So there is this sense that the court, the more conservative approach to substantive due process as well as to maybe equal protection is for the court to sort of play cleanup, to bring along the outlier states once a social consensus has been achieved on an issue. Now, if you're a constitutional counter-majoritarian, you sort of say, what good are constitutional rights if you have to wait until a majority of states and a majority of your fellow citizens already agree with them or not? But I think that's typically what the court is thought to be looking at is, let's wait for a few more states to do this. And my point is that this is kind of an unusual situation because in 30 of the 40 states that still explicitly ban same-sex marriage, that process is made much more difficult by the hurdle of having to unamend the Constitution in order to allow that, rather than just saying, well, let's get a majority of your legislators and let's do it.
Yes.
I'm curious what you guys think about the argument that the gay rights movement has too much power to need the help of the Supreme Court. Is that as crazy as it sounds, or is there some legal basis behind that?
I think the argument would be not that it has too much power, but that it has enough power. I mean, basically, this issue of political powerlessness has always been complicated when you move beyond anything less than formal disenfranchisement. If you get formal disenfranchisement, a minority group clearly is without political power, as African Americans were throughout the South. There's many parts of the South until the Civil Rights Act, the Voting Rights Act, 1965. So there you have a clear case of political disempowerment. Otherwise, with respect to the position of women in society, with respect to the position of gays and lesbians, it's much more, what sort of political power ought to exist in terms of justifying or not a special role on the part of the court to intervene rather than let the political process play out. So I think it becomes, and I think Mr. Sanders' points about when you put something in the state constitution, if you make it more difficult, that's perhaps different than if you have an otherwise, level and open political field.
Maureen Dowd Sunday in the New York Times had a really good column making just that point of gays being punished for their success.
Why is there such a categorical rejection of the federalism argument? Because it seems like it's a complete usurpation of a traditional state right to sort of regulate marriage. Maybe not same-sex marriage, but marriage. There's a traditional notion across the United States. So why is it just and the parties both like that? So why didn't they sort of rely on that? Because it sort of seems as if they viable.
I think it clearly works, it's fairly logical if you plug it into an equal protection argument. In other words, that the federal government has a lesser role to deal with definitions of marriage than do the states. It has a less significant power, and therefore that interest, it's working sort of only at the margins with respect to advancing any interest that might be served by definitions of marriage. The problem with the argument is that DOMA is a definitional provision that basically piggybacks and attaches itself to all of these provisions of federal law that clearly are justified under Article 1, Section 8. For example, the bankruptcy code, clearly justified under the bankruptcy code. Spending power clearly authorizes Congress to spend money and to do that in particular ways. Taxing power permits Congress to adopt tax laws, and the question is how does Congress then deal with the extension of benefits, taxation? Ordinarily, Congress has the power to make those definitions. So it's not a matter of, as Kennedy put it, directly regulating marriage. It clearly would be unconstitutional if Congress passed a statute saying every state shall henceforth recognize same-sex marriage. That would be beyond the Constitution, unless maybe you make some argument that that's what the Constitution requires. You might come up with some argument. Basic, under
Section 5.
Section 5 of the 14th
Section
Amendment.
5, you could make a good argument.
But then you'd have a very formidable federalism problem.
But you would then have a serious
Yeah.
federalism
But
problem.
basically,
Right.
this is not an intervention in the same sense. The best argument I've seen, Michael McConnell has an argument that basically analogizes. Federal courts have jurisdiction in diversity cases. There is an exception recognized for domestic relations. So basically, the argument would be that somehow marriage is uniquely for the states, such that the federal government cannot tinker with it, even if it is otherwise operating within the scope of federal power. That would be, I think, the best argument. It would lead to the implication, I think, that it would be unconstitutional as a matter of federalism for the federal government to extend benefits to committed same-sex couples, even in states that do not have same-sex marriage, because really that would be redefining marriage at the federal level, and the federal government shouldn't be doing that. So basically, and maybe Kennedy thinks that's the way it ought to be. That's conceivable, in which case DOMA would be invalidated on that basis, but the federal government would be precluded from doing anything other than honoring whatever state law happens to be.
But I'd like to jump in and just say a word in defense of the federalism argument, though. So 2 years ago, I mentioned we had Judge Walker here about a year and a half ago. 2 years ago, actually 2 years ago this week, I think, we had here Maura Healey, who was the head of the Civil Rights Division in Massachusetts. In one of the other DOMA cases, not the one that went to the Supreme Court, but one of the other numerous cases in which federal courts said DOMA was unconstitutional, one of those cases was Massachusetts actually suing in its own behalf, suing the federal government on basically a 10th Amendment theory, saying that DOMA infringes on Massachusetts's sovereignty. And so just to cite one example that Massachusetts talked about, many states operate veteran cemeteries. When the state buries a veteran and that person has an opposite-sex spouse, the state can also bury the spouse and get full reimbursement from the federal government for that veteran burial. If it buries the same-sex spouse of a veteran, the federal government won't reimburse the state. The state has to pay for that out of its own pocket. So just a simple practical way in which states are actually disadvantaged if they choose to, disadvantaged by the federal government, punished by the federal government if they wish to offer marriage equality to their citizens. So this argument has not been prominent in the litigation, but it has been made, as I said, most notably by Massachusetts, which brought its own suit separate from any of the equal protection cases.
And I would just add one, and it's not just that states wish to. I mean, states are compelled to, under the rationales of the state cases, it would be unconstitutional for them to make those distinctions.
Yeah.
Let's go here.
Why does there have to be a certain date at which banning marriage being unconstitutional? Why isn't it always been unconstitutional? It's just an error that wasn't realized until recently.
I think that's one plausible analytical response, that basically we just discovered it. whether that works, I guess, depends upon whether you believe that, in fact, there was a law review article written many years ago, does the Constitution mean what it always meant? And I think that is one logical response. We just haven't discovered the full meaning of the original provision. Whether that's persuasive, I guess, is a matter of debate.
I want to know that there's a lot of talk about the one-state solution, the 9-state solution, the 50-state solution, but it seems to me that even if you go on a rational basis, California's only advancing one purpose, potentially here, the responsible appropriative argument. Is it a possibility that the Supreme Court could say, we find that purpose illegitimate, and we find, for all the reasons you allow them to get kids, blah, 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 we find that purpose illegitimate, but leave open the idea that other states who have, who are in a similar situation to California, to have a different purpose that they bring forward, and then litigate over a new purpose, or are we going to foreclose on all states that have, 90% of the way under responsible appropriation? Because to me, that's a different. That would not require only one, only 9, and only 56 either.
I think that's the argument before the court. That's the interest being promoted because there isn't a better one. There is not. It's not like there's a stronger argument that a state will come up with in a later case. There's been lots of litigation in state courts and lower federal courts where other arguments have been put forward, and that's the one that is, has the most weight to it. And so, but I do think, like, the position of the Department of Justice, the government, in this case, is to try to walk a tightrope, and say, we shouldn't try to resolve, you, Supreme Court, don't need to resolve everything in this case. You can rule narrowly based on, like a 1-state or 9-state, and leave open some possibility. But I think it will be more that a state like California on its facts, where they allow gays and lesbians to adopt, and they do not take the policy position that is harmful to children, they're precluded from making that argument. And so you could rule narrowly on that ground, perhaps, and then let a state like Florida that has made a different policy choice and not allowed gays and lesbians to adopt, and I think the Department of Justice position is, let's wait for that case so that that state can fully present that argument on its facts, perhaps. But the justices did not seem very open to the argument that you can limit the reach of a ruling in favor of marriage equality to less than the whole nation.
Okay, one more question. Whoever back here speaks up first. I'm pointing toward 2 people.
Do you think that if they rule on the merits in the DOMA case and hold it unconstitutional, that opens floodgates that can't be closed at that point by creating a patchwork framework among the states, similar to what we're seeing in the era of Virginia and Dred Scott, that when the next case is brought, that the court will not be able to say anything but this patchwork is unconstitutional?
I come to somebody after class today that I think that whatever the legal rationales may be, I think the patchwork that is already beginning to exist and the interstate recognition issues, however those might ultimately be resolved, basically will propel this country toward nationwide same-sex marriage as a matter of practical necessity, maybe too strong a word, but to avoid all of the practical difficulties that are raised by the condition that is existing that probably will increase. Now, whether that'll be interstate recognition litigation, ultimately leading to, some problematic issues and problematic results, I suspect that those factors will influence the Supreme Court, maybe not this term, but if not this term, 5 years from now, or whenever this brews back up again against the Supreme Court. That's my thinking.
Thank you all. That was a great.